Hello, this is Chris Jensen, the Director of Clinical Services at the PCOM San Diego campus, and you are about to listen to the mandatory Hipaa training for all students, all faculty and staff associated with the clinic. This training is going to be about 30 minutes long, and at the end of this training you'll actually have a 14-question Hipaa training quiz that I'll need to ask you to complete and return to the clinic office as soon as possible so we can give you credit for this training. If you have any questions, because we're not physically together in this training, feel free to contact me at my office at area code 619-574-6932. All right, let's begin. The goals for our training today are to increase the knowledge and understanding that you have about what protected health information is and understand what threats may exist to its privacy and security. We're also going to enhance your awareness of your role in helping the organization following Hipaa regulations. And we'll also alert you to any possible penalties for violations of Hipaa for both individual providers and the organization. Maybe you've heard the term Hipaa. It's an acronym, HIPAA, and it stands for Health, Insurance, Portability, and Accountability Act. HIPAA, Health, Insurance, Portability, and Accountability Act. It became effective April 14th of 2003, and it is a federally mandated law, and it applies to us because we at PCOM are considered a covered entity. We are healthcare providers, but we fall under the criteria of a covered entity. And we're going to primarily be discussing the safety and security issues associated with protected health information, but the whole law itself we are responsible to uphold to the best of our ability. So this training is mandatory for you, whether you're a student or a supervisor, and you will be held responsible for what you learn today. So please listen carefully and take notes if you'd like, and we'll look forward to trying to cover as much as we can in a very short time. Why Hipaa? Why this law, and why did it come into effect? There's been a lot of overall advances in the information technology field that have impacted the electronic transmission of health data, including rapid growth of the internet to transmit and share an individual's health information, for instance, diagnoses, lab results, tests, prescriptions, things like that. There have also been concerns over rising healthcare costs. There's been an increasing use of electronic medical records. There's an increasing use of interconnected electronic information systems, a lot of sharing data back and forth, retrieving and sending. There's also been an increase in public concern about their loss of privacy. You're probably familiar with how a rampant identity theft seems to be throughout our country and around the world. And this is one way that we, abiding by these laws and patients understanding their rights, will ensure to the best of everyone's ability, I think, that very sensitive medical information is kept private. The framework of Hipaa, I'm going to give you a couple of terms that are important to know. First of all, privacy. That is the right of the individual to be left alone and determine who can access their individual health care information. Patients, like I said, have a lot more rights than they ever have had before, and under Hipaa, we'll tell you exactly what those are. Confidentiality is the responsibility for limiting disclosures of private matters, and security is the means to control access and protect information from accidental or intentional disclosures. You're around medical information all day. You certainly, as a student and faculty and staff member, have a right to access that information and share that information in the confines of your training and your education. However, there are accidental disclosures, for instance, laying records down, keeping records open where someone could walk by and see someone's name or any medical information. There's also intentional security issues, for instance, hackers that may try to get into our system, sending information over the internet, whatever the case may be. Also, workforce members, there can be issues with regard to former staff, former students, anyone that's currently here. We have a lot of students, several hundred, that come and go throughout this clinic throughout the year, and it's really very difficult to physically oversee every detail of what someone is saying or doing with personal health information. But anyway, this is important. All these issues are watched over carefully: privacy, confidentiality, and security. The highlights of the privacy regulations, and again, this is what we're going to primarily focus on today. Set standards governing the conduct of health plans, HMOs, and covered healthcare providers with regard to privacy and security protection for an individual's confidential health information. The privacy regulations include detailed standards regarding the use and disclosure of health information for the purposes of treatment, payment, and operations. You're authorized to disclose protected health information for the purposes of treatment, payment, and overall healthcare operations, and this is an important thing to remember. Privacy regulations and security for protected health information apply to all health information, regardless of the form. For instance, if it's written, oral, or electronic, these apply to all those areas. The privacy regulations requires us to keep all records of healthcare information up to 7 years. Each state is different, and California requires 7 years, and this is important to remember because we keep our records on file here locally at the clinic, but we also archive up to about 5.5 years of records in our storage, and we'll talk about destruction of those records later. The privacy regulation requires every healthcare provider to establish and adopt detailed privacy policies and procedures. We're to appoint a privacy officer, which is me here in the San Diego campus, and a security officer. That would be Al Comanda, who's over our facilities as well. We're required to post a notice of privacy practices at all of our sites, off-sites as well here in all the clinics, and provide patients with a written copy of the notice of privacy practices. We're required to train all new workforce members and retrain concurrent workforce members periodically about privacy and security policies and procedures. Documentation and retaining training records must be up to 7 years. The privacy regulations require us to establish workforce sanctions or penalties for any individual who violates the privacy policies. And these can be progressive discipline, including termination at the very end. Hipaa required written policies and procedures. There's a privacy and policy manual that is required to maintain the following information and is available in the clinic office. Privacy, confidentiality, and security for all health information. Privacy complaint and privacy rights violations. For instance, how will we handle those? How do we document those? How will we respond to them? Those are all contained within our privacy and policy manual. Administrative requirements to ensure physical safeguards for medical records, protected health information. We can designate who has what level of access, and we can keep certain controls over that information. The Hipaa required written policies and procedures include verification requirements for requested health information, needing to have a valid patient authorization from outside the organization, sanctions for workforce members who violate the organization's privacy practices and policies and procedures, retention and destruction. It discusses timeframes and methods not only for medical records but for HIPAA-related required documentation, policies and procedures, workforce training sign-in sheets, business associate contracts, privacy board waivers, patient complaints, and things like that. Business associate procedures and a HIPAA-compliant business associate agreement. We'll discuss what a business associate is and that agreement here in just a little while. I'd like to give you a couple of definitions that are important. The first is disclosure. That means the release, transmission, transfer, or the provision of access to or divulging in any other manner protected health information outside the organization holding it. That simply means we have to have regulations and procedures established in how we will disclose or to who we will disclose outside the organization protected health information. The next term is use. This means with respect to individually identifiable health information, the sharing, employment, application, utilization, examination, or analysis of such information within an organization that maintains such information. So we also have to define how we can use the information. And all of the students here, faculty and staff, generally have the same level of access as long as it's within the confines of your training. And that's what I would say is probably a good rule of thumb, that while you're in the practice of medicine here, on shift particularly, you have access to information. You do not have access and authority to take the records off-site. You don't have authority really to take the records out of the clinic without permission, And this HIPAA law has required us to monitor those records, where they're at and so forth, very, very carefully. The term healthcare operations means administrative, financial, legal, and quality assessment, improvement activities, training, accreditation, certification, reviewing competence, evaluating performance, fraud and abuse detection, business planning, development, legal services or auditing, necessary to run business and support core functions of treatment and payment. In other words, we mentioned earlier that you do have the ability to disclose and use protected health information if it's for the reasons of treatment, payment, and overall healthcare operations. So just be aware of what that term means. Also, treatment means the provision, coordination, or management of healthcare by one or more healthcare providers, which is what we do typically on a day-to-day basis here. And payment means activities of healthcare providers to obtain payment or be reimbursed for their services. So those areas are important to remember: healthcare operations, treatment, and payment. We have pretty much open access to protected health information with the following guidelines as well. The term minimum necessary standard simply means this: we must limit the health information used or disclosed for treatment, payment, and operations to the amount reasonably necessary to accomplish the purpose for which use or disclosure is sought. So if you're in the basic pursuit of treatment, payment, or operations here in the clinic, you have a responsibility to limit disclosing or accessing information about protected health information to the least amount possible to accomplish your job. It's always better to seek out less information than more, especially if you're going to be doing it outside the definition of your scope of practice or your training. Now, this term I'm going to give you next is probably one of the most important, and it's probably the crux of the whole entire HIPAA law. You're asking yourself possibly, well, what is protected health information? How do I know if I have it, or if I've seen it, or if I've disclosed it? Protected health information is health information, including demographic information, that identifies or reasonably could identify an individual, is collected directly from the individual, either by the covered entity or received by a healthcare provider, health plan, or employer, and relates to the individual's health, health care, or health care payments. Let me give you just a brief overview of what this means in layman's terms. If you have the identification of a patient and you can also relate that name to either their health care, or their health care payments, that information must be protected at all costs. Let me give you an example. In the lobby at the PCOM clinic here in San Diego, we have a sign-in sheet. The patient puts their name in, and we know that they're there for their appointment, and then the intern can come and call their name and take them back for treatment. Some have asked, well, isn't that a violation of HIPAA? Isn't that identification of who the patient is? Well, yes, it is. We do have to have some means to contact our patients and have some record of who's actually in the clinic. But as we just described by this term, the identification of a person alone is not a violation of HIPAA if you relate that to someone. But if you can relate any more information about their health care, or health care payments, if that form had information like that on there, and you could make an identification of who the person is as it relates to those things, and you divulge that, that would be a violation, yes. So the identification itself is not a violation. So if you're in the off-site clinics, or if you're here in the clinic, just be mindful of that. Anything, a record being open or laid out, or discussing information, if you make a connection with a person and their health situation, their health care overall, or their health care payments, and you do that illegally or even unknowingly, that can be a violation. And so I would say this as well, that obviously when you greet your patients, the first thing typically you'll say is, hey, how are you doing? And usually patients are quite open to responding to that question and telling you all the issues that they have and physical ailments they're going through and so forth. I would encourage you, from the moment that you hear this tape on, that when you go to the lobby and you call your patients, or if you're in an off-site clinic, try not to discuss their health care. Don't invite them to basically discuss their situation, because if other people overhear that and they know who you're talking about, it could technically be a violation of HIPAA. So what you might want to say as you greet your patient as, "Hey, Mr. Jones,